This next covers contract law when it comes to tendering, and also deals with how to end a contract. The next topic in contracts is the concept of a contract A and contract B. When you are requesting somebody to do work for you, this is called the tendering process. You issue a request for proposals, and companies will respond with proposals as they tender to do the work. The offer is the request for proposals, and the acceptance is submission of a proposal that's ultimately potentially successful. The process of actually bidding for work is a contractual process. So in putting out a request for proposals and in submitting a proposal, that's considered a contractual relationship. But it's not of value of the end contract. So there is a concept of a contract A, which is the tendering process. And then contract B is the contract that is then written as a result of the accepted tender. So when writing a request for proposals, if you issue a request for proposals and you get a number of bidders who are compliant with that RFP, you have to abide by the exact wording of your request for proposals when reviewing the bids. And similarly, if you submit a response to a request for proposals, that response is binding, and there is a penalty if you then don't comply with what you proposed. So in the contract A tendering process, the concept of unilateral mistake applies. So generally, if you make a mistake on either side, tough luck. But if you make a mistake in your proposal and you realize it before any proposals are opened, and you inform the person who sent out the RFP, then law recognizes that you aren't submitting the proposal you intended to, and no contract exists. You cannot resubmit, but you do not lose any money. If the tenders are opened and before the decision is made on who to offer the contract to, you realize that you've made a mistake and you're bidding on the work, then there may be costs involved in having to run another round of requests for proposals. And typically in an RFP, there are therefore limits defined in how much it would cost to run a new request for proposals. So under the principle of contract A, if you withdraw a proposal after the opening deadline but before the decision, you will lose the cost defined in an RFP for the RFP process, but you wouldn't be obliged to fulfill the contract. In terms of the case history for contract A, in the Bell River case, they realized the mistake immediately after having submitted their proposal, but before any of the tenders were opened. They told the people requesting the bid of this. The people who requested the bids appreciated Bell River's proposal as it stood, so tried to make Bell River commit to completing its contract as stated, or declare breach of contract. The courts found that because Bell River realized the mistake immediately and tried to pull out its bid before any of the tenders were opened, the bid wasn't the intended offer and they weren't liable for the cost of it. The concept of contract A was created in the Ron Engineering case, where Ron Engineering submitted their bid. They realized their mistake after the bids were opened, but before a contract was agreed on. And because the request for proposals had defined a specific bid deposit, Ron Engineering were liable for the bid deposit. They couldn't get the money back that they put in their bid deposit, but they didn't have to pay also for any breach of actual contract. With regard to implied terms, or terms that it would be reasonable to assume are implicit in a contract because the contract doesn't make sense without them, there are a couple of examples of case history that are relevant here. In the Hunter Engineering case, which we've discussed previously, Hunter Engineering had tried to sell gearboxes to Syncrude. However, the gearboxes were not fit for purpose. However, there was a very clear limitation of liability stated in the contract that said the gearboxes were provided as is, with no guarantee of being fit for purpose. Therefore, the courts took a strict interpretation, and the case was unsuccessful. In the second case history, a ship owner wanted to moor their ship in a wharf, and when they did so, the wharf actually drained of water, and at the bottom of the wharf there were actually things that damaged the ship hull. There wasn't any explicit term in the contract that said the mooring would be safe for ships, but it was assumed, and reasonably so, that in accepting to moor the ship at the wharf, it would be safe to do so. In order to end a contract, there are basically 6 ways that this can happen. The natural way to end a contract is when both parties have done what they said they would. This is by performance. It could be that both parties agree to end a contract because it's no longer relevant, or the work is sufficient for both parties' needs, and that's an agreement to discharge. It could be that the contract has specific clauses allowing the contract to be ended, for example, in the case of an act of God or bankruptcy. These can be express discharge terms. Other ways that a contract can be ended are through repudiation, where one side basically says they will not fill the contract, and the other side can then claim damages or choose to ignore the fact that the one side said they will not, and hold that other side to actually try to fulfill the contract. A contract can also be ended through frustration, where the contract is no longer possible to fulfill through no fault of either side, for example, an act of God. And finally, if one side doesn't fulfill the terms, but doesn't repudiate it, the other side can declare a breach of contract. And we'll talk about breach of contract in a future mix.